Connecting leasing to property management and risk. In earlier chapters, you learned that property management is the long-term, day-to-day operation of investment real estate. You saw how management agreements define the relationship between owner and manager, and how risk management depends on clear duties, careful documentation, and compliance with landlord-tenant and fair housing laws. Now we turn to the heart of the income stream, the lease. Every dollar of income, every maintenance obligation, and most disputes in a managed property trace back to what is written in the lease and how it is enforced. A property manager who understands lease types, rent structures, landlord and tenant rights, security deposits, and current fair housing guidance can protect both the owner's investment and their own license. This section ties leasing concepts you have already seen in basic lease law to the practical realities of management and risk control. Understanding leasehold estates. A lease creates a leasehold estate. The tenant receives the right to possess and use the property for a period of time. The owner retains ownership and a future interest called a reversion. When the lease ends, possession and full control revert to the owner. You previously learned 4 basic leasehold estates. They all appear in property management, and you must be able to recognize how they arise and how they end. An estate for years is a tenancy for a definite, fixed period. It might be 6 months, 1 year, or 10 years. But there is a clear start date and end date. Most commercial leases and many residential leases are estates for years. For example, if a retail tenant signs a 5-year lease beginning January 1st and ending December 31st 5 years later, that is an estate for years. When the end date arrives, the tenant must vacate unless a new agreement is made. A periodic tenancy begins as a lease for a definite period and then automatically renews for another equal period until one party gives proper notice to terminate. A classic example is a month-to-month residential tenancy. A tenant may initially sign a 1-year lease. When the year ends and the tenant stays with the landlord's consent, paying rent monthly and the landlord accepting it, the tenancy becomes month-to-month. Each month renews the lease unless proper notice is given. A tenancy at will continues with the consent of the owner but without a definite period. Rent is usually paid at regular intervals, but the arrangement can be ended by either party. And in many states, it terminates automatically upon the death of either landlord or tenant. Written tenancy at will arrangements are rare today because they create uncertainty and risk. A tenancy at sufferance arises when a tenant stays in possession after a valid lease ends, without the owner's permission. The tenant is sometimes called a holdover tenant. This is never a tenancy that parties deliberately create in a written lease. It is the result of a tenant failing to move out. The landlord then must decide whether to treat the tenant as a trespasser and evict, or to accept further rent and create a new periodic tenancy. Understanding these leasehold estates matters because they control how much notice is required, what steps must be taken to terminate, and what remedies the parties have when something goes wrong. Rent structures in leases beyond the time structure of a lease. Property managers must understand how rent is calculated. The rent structure influences the property's cash flow, operating risk, and marketability. In a gross lease, the tenant pays a fixed rent, and the landlord pays most or all of the operating expenses, such as property taxes, insurance, and routine maintenance. This is common in residential leases. For example, an apartment tenant pays $1,500 per month, and that amount covers the unit, common area maintenance, and standard services. The landlord bears the risk that taxes or insurance will rise. In a net lease, the tenant pays base rent plus some or all operating expenses attributable to the leased space. Net leases are common in office and industrial properties. For instance, an office tenant may pay base rent per square foot plus their share of real estate taxes, building insurance, and common area maintenance costs. As expenses change, the tenant's total payment changes. In a percentage lease, the tenant's rent is based in part on the income generated at the premises. A typical arrangement in a shopping center is a base rent plus a percentage of gross sales above a certain threshold. For example, the tenant may pay a base rent plus 5% of annual sales over $500,000. This structure lets landlord and tenant share in the success of the business. It is common in retail centers. Any of these leases can also be a graduated lease. In a graduated lease, rent increases are built in at specified times. A commercial lease might start at $20 per square foot, then rise by $2 every 2 years. A residential lease might lock in a modest increase each renewal period. Graduated leases give both parties some predictability about future rent changes and can be used to attract tenants by starting at a lower rate that increases as the tenant establishes their business. For property managers, it is crucial to read the rent clauses carefully, track when increases or percentage thresholds apply, and explain these clearly to owners and tenants. Misunderstanding the rent structure is a common cause of disputes. Owned and leased inclusions. A lease is not just about space and time. It is also about what is included and what is excluded. This affects maintenance obligations, insurance coverage, and even future disputes. In a residential lease, the agreement should spell out which appliances and furnishings are part of the rental. Built-in appliances, such as dishwashers and stoves, are usually considered part of the real property, and therefore the owner's responsibility to maintain. Freestanding refrigerators, washers, and dryers might belong to the owner, the tenant, or not be included at all. If the lease says that the refrigerator is not provided, the tenant must supply their own and is responsible for it. If the lease says the refrigerator is included, the owner should be prepared to repair or replace it when it fails. In commercial leases, inclusions and exclusions become more complex. Improvements, such as interior walls, built-in counters, and signage, may be provided by the landlord, installed by the tenant, or shared. The lease should specify who owns these improvements and what happens at the end of the lease. If a restaurant tenant installs a commercial hood and kitchen equipment at their expense, the lease may state whether those items remain the tenant's property to be removed at the end of the lease, or whether they become part of the building. Trade fixtures are a special category. These are items a tenant installs to conduct their business, such as display racks, specialized lighting, or salon chairs. By definition, trade fixtures belong to the tenant, and the tenant may remove them at the end of the lease, provided they repair any damage caused by removal. The lease should still address trade fixtures so there is no confusion. Inclusions also have an insurance dimension. An owner's property insurance generally covers items the owner owns and that are part of the insured property. If an item is not owned by the landlord or not identified as part of the leased premises, it may not be covered under the owner's policy. Tenants usually must insure their own personal property and trade fixtures. Clear lease language about who owns what and who insures what prevents unpleasant surprises after a loss. Finally, the lease should explain whether the tenant may alter the property and under what conditions. Many leases allow minor cosmetic changes, such as painting, but require written permission for structural or significant alterations. Some require the tenant to restore the premises to its original condition at the end of the lease, while others state that improvements become the landlord's property. Property managers must enforce these clauses consistently to protect the building and the owner's interests. Reversionary rights of owners. When an owner leases property, they give up certain rights for a period, primarily the right to exclusive possession. However, they retain a future interest called a reversionary right. This means that when a condition is met, usually the expiration of the lease term, all rights granted to the tenant return to the owner automatically. Imagine a tenant who rents an apartment for 1 year. During that year, the tenant has the right to occupy and use the unit according to the lease. They do not own the unit, cannot sell it, and cannot place liens on it. When the lease ends and the tenant moves out, the owner's full package of rights is restored. The same principle applies in commercial settings. If a tenant defaults by failing to pay rent or by seriously violating the lease, a court-ordered eviction can also trigger the reversion of the right to possess. Recognizing reversionary rights helps property managers understand why owners are so concerned with lease terms, renewal options, and default clauses. It also reminds managers that their job is to safeguard the owner's long-term interest in the property, not just this month's rent. Landlord rights and responsibilities. Residential landlord rights and duties are often based on a version of the Uniform Residential Landlord and Tenant Act, or similar state statutes. Most laws follow the same basic pattern. A landlord retains the right to enter the premises for legitimate reasons. These typically include emergencies, necessary repairs, showing the property to prospective tenants, buyers, or contractors, and verifying compliance with the lease. However, entry is usually subject to conditions. Except in emergencies or when the tenant has abandoned the property, the landlord must give reasonable notice and enter at reasonable times. A landlord who enters at random, without notice, risks violating the tenant's right to quiet enjoyment. The landlord has the right to receive rent as agreed and to expect the tenant to obey lawful building rules and lease provisions. At the end of the lease term, the landlord has the right to retake possession of the premises. If the tenant breaches the lease, the landlord can use the remedies provided by law, including serving notice, filing for eviction, and seeking damages. In return, the landlord has significant responsibilities. The most important is to provide and maintain a habitable property. This usually means keeping heating and cooling systems operable where required, maintaining plumbing and electrical systems, keeping stairs, railings, and walkways reasonably safe, controlling infestations, repairing roof leaks and broken windows promptly, and complying with local health and building codes. Landlords cannot avoid these basic duties by writing them away in a lease. In practice, property managers carry out many of these duties on the landlord's behalf. They must know where the legal line is between a normal repair and a serious habitability issue and act quickly when health and safety are at stake. Tenant rights and responsibilities. Tenants also have important rights under landlord-tenant law and the lease. The core right is the right to quiet enjoyment. Once a tenant has lawfully taken possession, they are entitled to use the property without unreasonable interference from the landlord or others acting for the landlord. They have a right to privacy, subject to the landlord's limited right of entry. Tenants are also entitled to live in a habitable property. If the landlord fails to correct serious problems that are their responsibility, tenants may have legal remedies. Depending on the jurisdiction, these remedies might include moving out without further rent liability, withholding rent under strict procedures, seeking repairs, and deducting the reasonable cost from rent after proper notice, or pursuing mediation, arbitration, or small claims court. At the same time, tenants have responsibilities. They must pay rent on time, follow the rules and regulations in the lease, and give proper notice when terminating a periodic tenancy. They must return keys when leaving, keep the unit reasonably clean and sanitary, dispose of garbage properly, use utilities and fixtures correctly, and avoid damaging the property. Tenants must also prevent their guests or family members from damaging the property. Many disputes arise from misunderstandings about these mutual rights and duties. A property manager who can calmly explain both sides' obligations and who documents requests, notices, and repairs reduces the risk of conflict and lawsuits. Evictions, actual and constructive. Sometimes, despite everyone's best efforts, the landlord-tenant relationship breaks down. When a tenant violates the lease by failing to pay rent, causing serious damage, or committing repeated violations, the landlord may have to pursue actual eviction. Actual eviction is a legal process. The landlord cannot simply change the locks or remove the tenant's belongings. Instead, they must follow state law and the lease. Typically, the process begins with a written notice describing the breach and giving the tenant a chance to cure within a certain time, such as paying rent within a few days. If the tenant does not comply, the landlord may file an eviction action in court. If the court finds for the landlord, it issues a judgment for possession. A court officer, such as a sheriff or constable, may then remove the tenant and their belongings if they do not leave voluntarily. After that, the landlord can retake possession. Constructive eviction is different. It occurs when the landlord's actions or failures make the premises unfit for the use described in the lease. For example, if a landlord refuses to repair a broken heating system in winter or ignores serious water leaks and mold, a tenant may decide that the property is no longer habitable. If the conditions are severe enough and the landlord had proper notice and reasonable opportunity to correct them, but did not, the tenant may vacate and treat the lease as terminated. The tenant may also seek damages. However, the tenant must usually move out to claim constructive eviction and must be able to prove that the landlord caused or allowed the problem. Because both actual and constructive eviction can lead to court and damages, property managers should treat violations and habitability complaints seriously. Follow written procedures and consult legal counsel when needed. Tenant improvements and build-outs, especially in commercial leasing. Tenants often need to modify a space to fit their business. These modifications are called tenant improvements or build-outs. They may range from simple repainting and installing shelving to major changes like moving walls, adding plumbing, or constructing a commercial kitchen. Most buildings have certain standard improvements, such as basic lighting, ceilings, and flooring. Tenant improvements may upgrade these standards or customize them. The lease should address who pays for improvements, who completes the work, and who owns the improvements when the lease ends. Sometimes the landlord provides a tenant improvement allowance, a dollar amount per square foot that the tenant can use to build out the space, with any excess cost paid by the tenant. The lease may require the tenant to return the premises to a standard condition at the end of the term. For example, an office tenant who built many private offices might have to remove them and restore an open floor plan, unless the landlord agrees to keep the improvements. These issues affect future leasing and the property's value. Managers must keep careful records of what improvements were made, who paid for them, and what the lease says about removal and restoration. Termination of a leases do not last forever. They terminate in several ways. And as a salesperson or property manager, you must recognize each one. Expiration is the simplest. An estate for years ends automatically at the end of its stated term. If neither party takes action to extend or renew, the tenant's right to possession ends. Performance terminates a lease when both parties have fully carried out their obligations. Rent has been paid, possession is surrendered, security deposits are resolved, and no obligations remain. Agreement occurs when landlord and tenant mutually agree to terminate a lease early. This might happen when a tenant must relocate and the landlord finds a replacement tenant, or when both sides decide that ending the lease is better than continuing under changing circumstances. The agreement should be in writing. Abandonment occurs when a tenant leaves the premises without notice and without intent to fulfill the lease, such as leaving in the middle of the night with unpaid rent. The landlord may retake possession and seek damages for unpaid rent and other losses. The tenant's obligation to pay rent does not automatically disappear just because they have left, although the landlord may have a duty to mitigate damages by trying to re-rent the property. Default or breach occurs when either party fails to carry out a lease covenant. Tenant default might be non-payment of rent, unauthorized occupants, or serious damage. Landlord default might be failure to provide essential services. The injured party may seek remedies, such as damages, specific performance, cancellation, or eviction. Constructive eviction is a form of termination based on landlord default. Notice is required to terminate periodic tenancies or tenancies at will. The lease or state law will specify how much notice is required, such as 30 days for a month-to-month tenancy. Proper written notice is essential to avoid disputes. Destruction of the property may terminate the lease if the premises become unusable. Condemnation through eminent domain, in which the government takes the property for public use, also terminates leases, though tenants may have certain rights to compensation. Foreclosure may or may not terminate existing leases, depending on state law, the type of foreclosure, and whether the tenant has special protections. Finally, death can terminate a tenancy at will upon the death of either landlord or tenant. If the landlord holds a life estate in the property, any lease they grant cannot extend beyond the landlord's life, because they cannot convey an interest they do not own.